2024 is a very interesting year in that we're finally, if depends if you're a consultant or an attorney for bankruptcy, we're seeing the bankruptcies go up. It's ironic that during the pandemic, especially immediately after the pandemic, bankruptcies that were an all-time low. And I'm pleased to be joined with Leo Jacobs, the CEO of Jacobs Law Firm, and they specialize in bankruptcy with a niche towards the real estate spectrum. So without further ado, I'm going to have a conversation with Leo, and I'm sure he'll provide us with some great words of wisdom with regards to this trend in bankruptcy as it pertains to real estate.
Well, I appreciate it, Michael. Thank you so much for inviting me onto this podcast to discuss bankruptcy as it relates to real estate litigation and real estate restructuring, both in and out of court. If you have questions for me, let me know. If not, I'll begin talking about 2024 and what happened in 2025, what we can expect.
Why don't you just take off and just talk a little? Let's talk a little bit about 2024, and then we'll spin into the a new year, and immediately after that, go ahead, Leo.
Sure. So when we began 2024, our firm began noticing a trickle effect from COVID. Now, COVID was in 2020, so the trickle effect took about 3 years. And what we began to see is that prices began to depreciate on real estate. And this goes beyond just the hotel multifamily sector. It also had actually included industrial as well as database types of spaces as well. And the inclusive effect of all of that was that the values began dropping. So a lot of clients began to call us and start discussing with us what they should do. And we came up with a process which is called preventative action and defense. Preventative being calling and emailing and discussing with your lender before a maturity default occurs or before a default occurs, taking action once a default is actually qualified, and defending in the event that there needs to be a defense. And I'll break these things down. So 2024 comes around, and there are 3 buckets. There's preventative, action, and defense. The preventative individuals would come to us and they would tell us, hey, Leo, I'm not in a maturity default yet. I'm not on the default, but I'm looking at the sky and it looks a little cloudy. So I want to just be prepared and have a discussion with you about what my options are. Typically, in that type of a scenario, we request the documentation from our clients and we begin to cursorily review not the matters that were already negotiated, but the matters that are typically not negotiated, which is the notice provisions, default provisions, acceleration provisions, and forum clauses. Forum is where an action can be brought. And that's the first bucket. The second bucket is the action bucket, where some clients in 2024, not as much as there are now, we'll discuss 2025 in a little bit, the action bucket is when they're already received a default notice. And typical default notice is either one of 2 ways. Number 1, there is an actual default to make a payment. Number 2, there's an actual acceleration of the debt. So the more graver concerns when you have an acceleration of the debt. And in that scenario, what we typically employ is what's called the reversal method. We attempt to reverse the actual default interest, or we attempt to ask the client whether they're able to pay all of their arrears. Now, it's not the same as when it is a maturity default. Reversing a maturity default takes a lot of actionable items, one of which is the objectives of the client. Typically, if it's a non-recourse loan, you have a discussion with the client to release the actual property to the lender and get off of any non-recourse or carve-out guarantees, as they like to say. Whether it be corporate or individuals that sign on, you have to basically make sure that they are off those guarantees, and they typically let go of the property if that is the objective. If the objective is to keep the property, there are certain action items that are developed, such as filing a voluntary bankruptcy petition or engaging your lender to discuss any lender liability claims that might actually be present. Now, the defense bucket is very, very different. It's when the client is already behind the eight ball, the default has been sent, or the reservation of rights, the default notice, the acceleration, and now there's a foreclosure that has actually commenced. Now, in that particular bucket, the client is unable to afford the payments. Their debt has in fact matured, and something else actually occurs. The joint venturers or the shareholders of the typical company that owns that piece of real estate or that company in general, they begin to have discussions with the actual management team, which is the CEO, the CFO, the COO, or if it's a closely held corporation, your brother, your sister, your mother, or if it's an institution, the actual management board and the board of governors. They begin to look at their debt to equity swap. They look at their equity distribution, their preferred rate of return, and they say, look, this value is no longer here. And it's typically the fault of the management team, perceivably, as the reason for it. But what we have learned in 2024 is in all of those buckets, right? It's really 2024's climate or market that has shifted from valuable real estate to depreciating real estate. Now, there's a reason that this is all occurring. Number one is the political climate. Number two is that the interest rates with the Federal Reserves have gone up. Number three is that laws have changed as to how multifamily is treated, really either across the nation, but specifically in New York. And there are new regulatory requirements with environmental CO2 emissions and other emissions from a piece of property that have made it unviable to have a discussion
Now,
about what the value of the property is. Yes.
in the 2024 spectrum that we're talking about currently, have you found that the financial institutions are more flexible with regards to giving them a restructured runway?
So I'm going to have a discussion about that. So we've discussed the three buckets. Right. And the first, second quarter, you had, say, we'll give it a value. Say in the first quarter, we had, 10 of them, which is preventative, 10 of them, which was action, 10 of them, which was defense. Now, today, when we move to second quarter and third quarter, you begin to realize that the sentiment is really, really changing. And it begins to change very, very rapidly. It's like a rapid onset where, all of those numbers have now tripled or quadrupled. So you begin to see that the economy is not doing well because extensions of time, although are given, there needs to be a significant pay down of the actual loans, right? And some cannot afford them. So they go from a preventative bucket into an actions bucket, then they go into a defense bucket. We're in the last quarter of 2024. To state this lightly, we've received in the last 3 weeks about 27 or 28 increase of new action items, whether it be action or defense items, no longer preventative, because there's another bucket that has been not paying attention to what's going on, and it's those people that put their ostrich head into the sand about not doing anything. There's a fourth bucket, and that fourth bucket, I think, has finally woken up. I think the real reason that they have just woken up is because they feel that because of the political climate, whether you're for Trump or against Trump, that's not the point here. Things will become better. Well, I have some news for those folks. Things are not going to become any more better than they were when you signed the documentation that you signed. It's important to understand that when someone signs a contract, they have to live up to their agreement. And many of them have not. And those four buckets are going to become very, very important in 2025. With lenders, just to answer your question, lenders have not provided any restructuring runway to the extent that they wanted to, delay and pray or extend and pretend, right? That's the moniker you've been hearing a lot. But that does not put neither the bank in a better position or the borrower in any position. And when we're discussing this as a matter of business. This regards your vendor-vendee relationship, borrower-lender relationship in real estate. It could be a bodega. It could be a Blackstone subsidiary. It could be Blackstone itself, right? Or it could be an institutional advisor to a family office that has invested in real estate in New York City, Alabama, Nashville, Tennessee, Florida, so on and so forth. So both sides actually have been having trouble getting debt off of their books. We typically think of a borrower as someone that is on the receiving end from a lender. But let's not forget that lenders are actually caught holding the actual bag, because the lender works with a specific timeline, qualification metric, right, when qualifying borrowers. And number three, they're picking the borrowers that they want to do business with. So they pretty much have a very specific, right, way of doing business, because they're targeting specific borrower class, whether it be multifamily, hotel. So every sector that they're giving money to, they're stuck holding the bag of that actual sector. So what happens is a precipitous decline in the value of the loan book that they have, and what's called a tier 1 ratio for the bank or institution to be able to give loans on the books. So just to give everybody a quick synopsis of what the hell I just said, a tier 1 ratio is the ability of a bank, meaning its liquidity, to give out more debt on the street. If that liquidity essentially goes down, they can no longer give any more loans. And if they can't give any more loans, the bank cannot have any more assets. Now, it's a bit counterintuitive. Typically, we conceive a loan as a debt, as a liability on a balance sheet. But with the bank, because their business is to give out loans, they're considered assets. And if you can't have any more assets, guess what you have? You have a declining, depreciating asset from the lender side too. Basically, not to get too complicated, because the lenders have been giving out actual loans in a specific sector, they're all over leveraged, whether they like it or not, because the modifications that have ensued are agnostic to any actual relation of whether it's a hotel, a multifamily loan, or otherwise. So both the lender and the borrower have been caught with the bag. And really the culprit here is the market. The market sentiment has changed. Along with the politically driven climate of the Trump administration, we have to figure out whether we're going to see a continuing precipitous decline in the piece of real estate, or the real estate that someone may own, to then talk about 2025 and what we're going to see. Michael, if you'd like me to continue to 2025, please let me know. If you have questions.
One more point before we jump into the new year. We're recording this literally at the end of 2024. Is that, as you stated, Leo, there's too many groups and organizations that play the ostrich and put their head in the sand and hope they don't go from one bucket to the other. And I found over my career, it's best to reach out to a prestigious firm like Leo's and do an analysis earlier before you're really in trouble. Because
it's Jacobs PC, not Jacobs Law, Jacobs PC.
Jacobs PC.
Jacobs, Jacobs, Jacobs PC.
Yeah. And to get a plan in there so you don't go from one bad bucket to a worse bucket. And also, the earlier you are in this process, whether it be with our firm getting the valuation or starting all the paperwork and everything for bankruptcy, you have so many more options in the early stages, using the bucket analogy that that Leo outlined, than if you're forced into bankruptcy and other means. You can always restructure. You can look at other options. Now, a lot of people have been waiting, right, wrong, or indifferent, Leo, as you stated. No matter how you are politically, the election's going to decide so much. Well, we're beyond that point. So what do you see now post-election, Leo?
So before I answer that question, I'd like to answer how your company and my company can actually work together. Typically, when someone is in the first bucket, which is the preventative bucket, values are extremely important to figure out. The reason they're important to figure out is because there is some type of deficiency amount that the lender will go after, whether it be a piece of property that the borrower owns, corporate or otherwise, whether it be the guarantor, the guarantee, the obligations of the actual corporate debtor, and its printers or its farm machinery or its piece of real estate. One must obtain the value, the fair market value of their piece of real property or personal property. Personal property being a tractor, right, on a farm, real property being the farm itself. And if you've financed your personal property and if you've financed your piece of real estate, it would behoove that individual that before maturity default or an event of default comes, that valuation, assessment of the financial health of the company, and the tact to be used with your lender or your joint venture or equity stakeholder is assessed. And I think your company does that quite well. You dive into the finances, you dive into the values of real property and personal property, and you dive into the tact that you'll take with your joint ventures and your equity holders. What it comes down to is a value. Now that I've said that, Michael, I'll go into 2025.
Thank you.
Like I said, in 2024, we began seeing a precipitous incline of those three buckets, right? Preventative, action, and defense. In 2025, we are going to be dealing, me and you are going to be dealing with the lack of action that has been taken by the fourth bucket, which is the negligent bucket, which is the bucket that has not done anything. What does that mean? They've let their properties go into receivership. They've let their properties go into a deed in lieu situation, which I will discuss both of these issues. They've let their properties go to judgment. Their guarantees have been matriculized into judgment, right? And those people are going to have a very difficult time returning to the preventative, action, or defense bucket. So in 2025, we're going to see a precipitous, real incline of those three buckets and a strong incline of the fourth negligent bucket. What does that mean? It's going to culminate in a lot of litigation between 3 or 4 parties. This is the Shakespeare's play, right? It's going to be the vendor, the construction contractor, the plumber, the engineer, right? Then there's the lender. Then there's the joint venturer. Then there's the partner, right? The joint venture and the partner had a preferred rate return. They failed into discussing their, ultimate settlement with the management company or the initial visionary that took them into, this property or this business of theirs. Again, whether it be a bodega, a popcorn factory, a manufacturing company, a retail company, a pool, a refurbishing company, a real estate company, whatever the company might be, those actors of the Shakespeare's play are always, in fact, or indeed present, whether they're your cousin, your brother, your mother, your father, your institution, your family office, et cetera, et cetera, et cetera. So those relationships are going to get strained, not because you have a problem and you can't fix it if Michael and Leo come along, but it's because emotions are going to run high in attempting to resolve the issues that are at hand so soon, so quickly, without any notice. So think of it this way. The psychological demise is going to occur because those that were ostriches and didn't take care of or have discussions a year ago to date from 2024 to now are going to have a difficult time even getting across the message to their joint venturers and their partners and their lenders that they want to begin to take action. And a lot of it has to deal with the anxiety of decision making. And decision making is an important trait to taking action, because if you are frozen in time in your situation, and you could be a billionaire today and still have the paralysis of decision making. In fact, the higher you go up, the less you are to make a decision, because those decision making powers are a bit different exercise now than they were a few years ago or even a year ago, because everything was good. I always give the example of Chamberlain appointing or discussing with Winston Churchill's duties, to which Winston Churchill has responded to his own dismay that he can't run the country the way Chamberlain has ran the country, because Chamberlain has ran the country in a different time. In fact, that's why Winston Churchill is necessary in those specific times. And the types of discussions that Winston Churchill is going to have are that and very much different than the ones that Chamberlain was having with his constituents. Typically, in a Chamberlain time, constituents would listen to Chamberlain. The Chamberlain would have to listen to the constituents. But in Winston Churchill's time, it's the constituents that have to listen to Winston Churchill. And the reason for that—
it's a very interesting analogy, Leo, because the same audience, Churchill's time has changed dramatically, and it turned on him because he didn't change with the times.
That is correct. That's why he thereafter got fired and came back again. But we're talking about that specific time in World War II, and we are at war, whether the people would like to hear it or not, whether they can deal with it or not. Winston Churchill had to tell people what to do. And that people will maybe disagree with me here on the video, but I frankly do not care, because those individuals are what we are in the emergency room. You're no longer, about a year ago, 2 years ago, having a discussion with your joint venture or partner, institution maker, and lender or vendor. You're no longer having that discussion with them when everything is good, when everything is paid. You're having those discussions with them in a very psychologically pressurized time frame. Yeah. And that's valuable for everyone to hear, those that are listening, because it's going to change the complexion of your decision making and your decisions you're going to make. So in 2025, we're going to see a lot of, just to wrap it up, we're going to see a lot of individuals not being able to make decisions, and they're going to have to find a Michael or Leo to make those decisions for them. Because if they don't, they're going to have a very difficult time paying their guarantees or fixing their relationships with their friend, mother, father, cousin, institution, if they don't take action and take it quickly.
I fully concur, Leo. And for our viewers, though, it is very important. The sooner you get into this process and explore your options, you do have more options, and you do have more flexibility with your creditors. If you're already knocking at the door, over half your options are gone. Correct. And it becomes very expensive from a legal perspective and a whole host of other reasons. Leo, I want to thank you for your time, as always. And I look forward to working with you again in 2025.
Well, I appreciate your time, Michael. Hopefully the discussion that we had today is a little bit of an eye-opener, and we can both make a difference for the people that are listening, so they can pick up the phone and say, you know what, I think I got to talk to Leo and Michael about the issues that I'm having, either the issues that are preventative, action-based, or defense-based, or if I'm ignoring them in all of its entirety. So thank you.
Thank you.